Welcome back to our third lecture in which we're going to cover how to format um, court documents in more detail. So we've covered the caption and we've covered the title of the document. So now we're going to move on to the body. Obviously, in the real world, writing the body is going to be a very time-consuming part, certainly where you're going to be spending the vast majority of your time. But in this course, we're really not focused on the mechanics of the content, but instead focused on the formatting. And so in many respects, the body has less formatting issues in it than the other portions of a court document. So in some respects, this is the easier section, although certainly in the real world, it wouldn't be. So let's get started. So the first thing that we're going to do is we're going to switch from having single space to having double space. So we go up here again to our spacing and we're going to choose double space instead of single space. So I'm going to start right here. We're going to also start on the left margin so that we have that formatting correct. Okay. There are lots of different formats, and there is some variation that different law firms will use for different formats. I'm going to show you several so you can get a sense as to the diversity of those particular formats. Let me get started with some examples. So here we have a pleading, and you can see in this pleading that the author, the writer, is double spacing this. He's putting the number on the margin and he's tabbing over. And then he has sections identified. This is a very common system. So they would use a Roman numeral with a period at the end. Then on the next line, they would indicate the category of information. And then they would continue to have the paragraphs over here. So this Roman numeral isn't going to match this number over here. We'll have sections. You can see we have the discovery level section, the party section. These are very common ways of choosing to do it. Jurisdiction and venue, and as these some law firms will separate these two. And then we have the facts. These also can be called general allegations. And we'll have the causes of action, and you can see they're made more granular with A's and then B's and then C's. And then we have our final section, relief sought. You can see that the numbering continues, so we don't restart the numbering with each section. This is 1, 2, and the numbers continue to increase. The reason that we do that is so that we can refer to, paragraph 14. If we had, a paragraph 14 in each one of the sections, it would get to be quite confusing. So here we're going to start, even though this looks like it's a new area, we're not going to start with 1, we're going to start with 13 because we have 12 above. So here, if you refer to 14, it's unambiguous. This is the particular paragraph that I'm drawing your attention to. And you can see everything in the body is double spaced, even though the caption is going to be, at least in portions, single spaced. But we have other examples, and here we have interrogatories. And while it's not necessarily wrong to double space, you can see here that there are areas where the party single spaces. For example, the to section. Again, this is a discovery tool, so it's not going to be filed with court. So we're telling the opposing counsel, or in this case, this person is pro se. Actually, I guess it isn't pro se because we have the attorney of record after here. This section is double spaced, but this section where we actually have the questions is single spaced. And most likely when Bonnie Raitt, the attorney, types in the answer, here it's going to be single spaced as well. But then there is spacing between the sections. You can see we go through these interrogatories. We have the definitions. A lot of people, when they were preparing interrogatories, would put the definitions at the beginning. That's the more traditional place to put it. And they have chosen to put the definitions single-spaced. Again, you could go either way with this. There's a little bit more flexibility on discovery. With our answer, we have our format here. Again, you can see that here, because it's such a short answer, that they chose not to number the paragraphs. Again, what's the point of numbering when you really only have 2 paragraphs? So that's fine here. One thing I would comment upon is that the paragraphs aren't indented, so that's less than ideal. Let me go to I guess those are the, actually, we'll look at some other documents in just a minute. Okay, so at the beginning of many pleadings, you'll see something called the comes now paragraph. This is kind of an introductory paragraph. Many legal writers don't use this because it has a lot of legalese. It doesn't sound right to our ears, but you will see this commonly, so it's a good thing for you to kind of be familiar with this particular style. So typically when you have a comes now paragraph, comes and now are all in capital letters. The rest of the words are going to be capitalized as you would normally capitalize. So we have comes now, plaintiff, JCPenney Company, Inc., and complains of James Dixon. I'm going to add defendant, James Dixon. So let's look at a few things. Well, first of all, if we had more than one plaintiff, we'll see plaintiffs JCPenney and Harold Brown. Be nice if I could spell it. Okay, here we go. So now we're going to have to change the comes now to come now, because we would say they come now, right? So come now, plaintiffs, because really we're just inverting the word order. Plaintiffs JCPenney and Harold Brown come now and complain of defendant James Dixon. So that's, again, a very traditional way to start a lawsuit. But there's no need to necessarily use that kind of archaic language. And I think actually most people would probably say, though, that that's to be avoided. Let's look at how the complaint that or excuse me, the petition that we have here is drafted. It says Larry Baxter is next friend of Madeline Hebert, a minor, files suit against defendant CEC Entertainment, Inc., DBA Chuck E. Cheese's as follows. So this has removed the comes now structure. It contains the same information, but it's a little bit more of an approachable way of saying it. So that would be an alternative to the comes now. You don't need to include it, but it's so common that it's not a bad thing, not something I would be concerned about. Now you may wonder about this material in quotes here. You can see here that after plaintiffs JCPenney Company, Inc., we have open parens with a quotation mark. Then we have JCPenney, close quotes, and close parens. What we're doing is we're defining this term, plaintiff JCPenney, Inc. We're saying instead of typing this long name, we're going to use this instead. This is like a nickname. It's a defined nickname. And instead of typing out the whole name Harold Brown every time, we're going to refer to him just as Brown. And instead of referring to defendant James Dixon each time, we're going to refer to him as Dixon. So whenever I use the term Dixon, it has to mean defendant James Dixon. Let's say James Dixon is married to Susan Dixon. Well, we've already defined Dixon to mean defendant James Dixon. So Dixon by itself can't mean Susan Dixon. There's a one-to-one correlation there. Similarly, let's say we have JCPenney has several subsidiaries, many of which have some form of JCPenney in their names. Well, we've said this particular entity is the one that is JCPenney. Any other entities aren't this person. Similarly with Harold Brown. So these definitions are really important. It allows you to use shorter versions of the name. And again, this entity name is our longest. It's not super long, but you can have entity names that take up 1 or 2 lines. And so you can see how that's disruptive of the flow of the document. So you'll see these definitions very, very commonly. You'll sometimes people will write hereinafter. That is an unnecessary terminology. We don't like to use that anymore. It doesn't accomplish anything because it's obvious in the context that we are using this defined term to represent the this is the defined term and this is our definition. So let's consider, we've already talked about the discovery documents and that for those we're going to have that to section. Now the way that the to section that I just showed you is formatted is that the two-section information is all on one line. Typically, it will include the attorney's name. In this case, it includes the party's name. And then it will include the physical address, and you can see it has a street address and also a city and state. This can be presented just in this format, but many times it's done like this. Actually, this is PDF, but that this would be on the second line, and this would be on the third line, and this would be on the fourth line. Either way is fine. Let me show you. Again, we do the to section because it really is to opposing counsel. It's not to the court. And so it wouldn't make sense to do that if we were filing it. If this were actually going to the court, then it would be silly to say it's to opposing counsel. Well, no, I mean, we're giving them a copy of it, yes, but that's for the certificate of service. But we don't include this to section when it's actually to the court. Here's an example of it. Now, this is not in Texas, so we see a different format for the caption. What I'm focusing on, though, here is this to section. It shows you how that's formatted. This is also perfectly acceptable to stack them in this way. Either way is fine. Again, this is a discovery tool, and that's why we have the to section. Okay, so now we've already talked about the comes now paragraph. A lot of times you will see before the comes now paragraph that there's a section to the Honorable Judge of this court. This is kind of analogous to the to section we have here. To, I can't pronounce this name, but we'll say it's Bob Smith, to Bob Smith. Just like you're addressing it almost like a letter or an inside address, although we don't technically use an inside address in court documents. Well, the equivalent would be when it is a document that's going to be filed with the court and that we do want the court to review, we could say to the Honorable Court. And so that's a very common thing that you'll see. You'll see it maybe less commonly now. Again, it's one of those somewhat archaic versions, so it's not necessary, but you certainly can do it. You can see this document doesn't include that kind of language here. It could, but this one just doesn't happen to. Okay. Now, let me introduce you to the term boilerplate. If you haven't seen that term before, there's a lot of history with it. Has to do with how newspapers were once made. But putting that aside, there are certain clauses and phrases, especially in contracts, that are set and kind of in stone. And when a law firm is, or when a legal professional is building a contract or other items, he or she is likely to use these already drafted sections, kind of plop them into the document, maybe change pronouns around if it was a he and now it's a she, or if it's a they and then now it's a she or a he. You make some changes like that, but the bulk of the language is going to remain unchanged. We don't have as much of that in litigation, but we do have some of that. And an example of that is the comes now. We'll also look as we go forward at another example. Let's look here at another comes now section. And you can see here, let me scroll, see if they have it. Actually, this is probably the best version of that. Let me blow it up a little bit. We can see here, you can see a more complex name for this particular matter. This is a nice caption, by the way. We can see that we have the cause number spot up here. We don't actually have it put in because this is actually a petition. We have the plaintiff on the left margin. We have, it looks like there might be a comma there. We have nice section symbols all lined up. We have plaintiffs indented. They did it more than one tab, but we're going to do one, and then there's a comma. They indented the V. We're going to keep our V over here. We have the party's name with a comma, and then we have defendant. We used an S here on plaintiffs because this is a class action, so we're including other people, not just Joan lawyer. And then we have only one defendant. You can see here, maybe they could have moved this up one little line, but that's okay. And you can see everything lines up really nice here. They put some borders on here. That's a nice look. It's not necessary. We're not going to do that in this class. And you can see they start to the Honorable Judge of said court. Better to say this court than said court. Said court, said is one of those old-fashioned expressions. It's just a way of saying this in this context. And you can see here they have come now. Come now, plaintiffs, Joan lawyer, individually on behalf of others similarly situated, and file. So these plaintiffs come and file this original petition. So this gives you an example. And you can see they've defined everyone in this group, Joan lawyer and her, the other people in this group, collectively as class plaintiffs. So everybody here is part of that class. They haven't chosen to define Equifax Inc. Perhaps they chose not to because it's not a very long name. So this is an example of some of that boilerplate. See, here's another example that we'll look at. Not sure why that's not popping up. Here we go. So you can see again, similar to what we have in many respects, but there's some differences. You can see here's the stamp here showing the time that it was filed. You can see that this one was right, justified. These don't line up, but this lines up. That's not what we're choosing to do. You can see they have this capitalized with an S, which we don't use. And you can see they don't talk about the party designation. There's no plaintiff here. There's no defendant here. So there are some differences. This language here for the introductory paragraph is a nice one. It doesn't use any of that archaic language. It begins, Harris County files this original petition in this environmental enforcement action complaining that, and names the party, then it defines it in parentheses, an Audi of America. This looks like a typo, this N right here. And then in quotes they say Audi of America, collectively Volkswagen or the defendants. So they're saying both of these together. If I talk about Volkswagen by itself, it's Volkswagen of America. If I talk about Audi of America, then it's this one. But if I want to talk about both Volkswagen and Audi, I'm going to use either Volkswagen or the defendants. You know, one of the reasons that you want to have two terms is it can get very repetitive and very kind of sing-songy if you're constantly saying one particular name. So that's why you sometimes give yourself some choices there to kind of makes it artistically or um, sound more literate in that sense. Let me just show you how you might begin another lawsuit. This skips over that kind of introduction. This is a little abrupt. So you can see they don't have any introductory section. They just jump right into the discovery level. Discovery in this case is intended to be conducted. There's no greeting. There's no kind of setting the scene. It's okay. There's nothing wrong with this, but it's probably a less desirable way of setting this up than if we were to have even just a one-line introduction. Be a little bit more elegant. Okay, we've talked about how we would number paragraphs. Let's just look at this for a second so we can see that practice. You can see here for this particular divorce petition, they chose not to number paragraphs, but we can also see it's a really short document. Here, this petition, also not numbering of paragraph. Actually, once they get beyond the first page, they do start numbering paragraphs. And you can see they happen to choose a different numbering system. Since this is Roman numeral 1, they put the 1, and then each one of the paragraphs are numbered after. Roman numeral 2, we see a 2 here in the number. This pattern I've seen before, but it's not the usual pattern. I wouldn't recommend it. I think it's less likely to be understandable. This system is much more common. You can see again in these examples, we have the Roman numeral on one line with the period and then the title. And then you can see, actually this, I didn't choose a good one, sorry. Pick this one. And then you can see their number. They don't start with number 1, they continue on from there. Okay, so that's a good model to use as you number. Let's just look at a couple of examples here so you can get a flavor. Some more. Some of these might be repeats. I think we've already looked at this one. Yeah, this is pretty much a repeat of the style that we already looked at. We can see this is a really nice caption. It's right justified, so less ideal. We'd really like to have these lined up on this side, not lined up here. But this side of it is exactly what you're looking for. You can see a nice name, and you can see even though, well, that's going there, but you can see each paragraph is numbered. It's not unusual that this first introductory paragraph is not numbered. In fact, I would say it usually is not numbered. It's really when you get into the nitty-gritty that you start numbering your paragraphs. And let's look at this one. So here we have, again, nice caption. They chose to italicize. Again, I would go with a straight line right here, and I would go with cause number in front of it. But other than that, it's a really nice formatted caption. And you can see they started to the Honorable Judge of said court. They have that introductory paragraph, which they're not numbering, but they number others. You can notice that all of the indentions are going to be consistent. Again, you're going to want to go with a tab and not a space here, because when you make the transition to 10 or 11, you want this P to line up with the 9 just as the P lines up with the 10. You're only going to get that if you're actually tabbing instead of spacing. So after you've completed your body, you're going to add one blank line before you begin your caption. I have an example here. I happen to add a line because we're going to talk about this later, but we don't want to start our signature block at the beginning of a page. We want to have at least some of the body on the top of the page. And so here I've ended, I didn't even write anything that makes any sense, but I ended in their document with 2 lines. That's the minimum you want. And then I have a blank line. And now I'm ready to start with the signature block, which we'll cover in more detail. So here are some pointers to think about. We've talked about the grammar things before, obviously. We want to make sure that we're proofing. We want to avoid passive voice. We want to avoid sentence fragments. We want to use commas appropriately. All of that goes without saying. Structurally, though, we want relatively short paragraphs. This is even more important in pleadings. Because if you have, a page-long paragraph and then you want to cite to that paragraph, you're asking the reader to read a whole paragraph, a whole page. Better to have 3 or 4 lines in a paragraph. There's no requirement in this area, but again, it's designed to be a really approachable document. Very likely the jury will have access to the pleadings, and many of those individuals are not going to, in fact, virtually none of them are going to be legal professionals. Many of them may not even have completed high school, and so their comfort and interest in reading may be less than another legal professional. You have to consider the potential audience that you have. You can see in these documents that we have lots of headings. You will rarely have a single page on a legal document that doesn't have a heading. So you're going to want to have those. I would say if a document is over 2 pages, you're going to want to have headings on pages. If it's the first page, maybe not. If it's the last page, maybe not. But I would say probably 2 headings a page. I'm not going to say there's a rule about that, but probably on average at least 2. And you're not going to have a heading for every single paragraph, but there will be many paragraphs where there is a heading where there is just one paragraph in that under that particular heading. One thing you don't want to do is break up or separate the heading from what goes after it. And so you don't want to end a page with a heading. If you find that you are in that situation, let me just give an example of that. So let me just say I'm going to we'll call this one We'll say we're up to paragraph 10, and we're going to say prayer for relief. And I'm going to put this in bold. You don't have to, but it's a very commonly done thing. And I'm going to tab on down. Obviously, we're going to pretend that where I have these tabs, we actually have content. So obviously you wouldn't have big empty spaces. But it might end up that you've had all this lovely content up here, and it just so happens that naturally the document breaks pages at this point. And so the content of section 11 is on the next page. You don't want this. You don't want to end it on this page. Now what I suggest that you do is don't even worry about where your headings break until the very end, because you're going to be moving paragraphs around, adding to and subtracting from. It might resolve itself naturally. You might find like you add 2 lines and oh, it's on the right page. But it is a good practice at the end to go ahead and look through and make sure you don't have any headings on the bottom page. Now there's 2 ways you can fix it. One way you can fix it is just to hit enter twice and get it all lined up. That's not a terrible way of doing it, but it's not the best way of doing it. For one thing, if you end up making a slight adjustment, what could happen is, let's say we end up adding another line up here. Well, now you have your um, this section not at the top of the page. That's less than ideal. Another reason that it's less than ideal to just hit the enter button again and again is that some versions of Word are formatted slightly differently. And so when I open my version of your document, it might be that somehow or another it has one more space, or somehow or another it has one less space. Well, you can see how you could lose a point, even though on your computer it looks perfectly fine. So how do you fix for this? Well, the solution for it is the Control Enter function. So what you do is you hit the Control button. This is on the left side of your keyboard at the bottom, and it's right below the Shift button. So you hit that, and then you hit the Enter key. And when you hit those two, it creates a page break. And now no matter what computer it's on, there will be a break here. This isn't going to accidentally be pushed up if you say remove a line above, and it's not going to be pushed farther down the page if you add a line. So it's a way to kind of control it to some extent. Now obviously one thing that can happen is you can have blank pages when you have the page command. That can absolutely happen. Let me show you and prove to you what you say. See? It stays right here. But let's say that I ended up adding my page added significantly. Well, what happens is the page break will go to the next line and I have a whole blank page. So there are some risks even with this approach, and that's why at the end when you're done with your document you do have to go through each page and make sure you don't have any of those formatting issues. But we have managed to square this away. Okay. Another thing, oh, here we go. Let me see where we are. So sometimes people, when they're using forms, will inadvertently start using something that is really intended for a pro se crowd. You may recall pro se is the term that we use for somebody representing himself or herself instead of having an attorney. So a big difference between pro se documents and documents prepared by legal professionals. Well, there's lots of differences. Obviously, the one prepared by legal professionals is a lot better, a lot more articulate, a lot more pleasing to the eye, and just better. Obviously, because we're legal professionals. But one thing that you will see in pro se documents, and this is actually appropriate for pro se documents, is that you'll see a lot of I's and me's and mine, because the actual person who's filing the lawsuit is signing the document. And just like when I write a letter to you and sign the letter, if I refer to myself, I'm not going to say Cynthia Groover. That's weird, and nobody calls himself or herself by the full name. They say I. I do this, or maybe if I'm writing a letter to the client, I might say, Dear Mr. Green, I am the paralegal assigned to this case. I wouldn't say Cynthia Gruber is the paralegal assigned to the case if Cynthia Gruber signed the letter, right? So you don't want to have any I's or me's or my's unless you're quoting from something. Because again, the attorney is going to sign the document. Well, the attorney isn't seeking a divorce. The attorney is not personally suing anybody. The attorney is representing somebody who that's true for. So when you start seeing I's, me's, mine's, you know you've stumbled onto a pro se document. That's something we definitely don't want to use. Even if you were to change the pronouns, it's still not the type of sophisticated legal document that your client is expecting you to prepare for himself or herself. Okay, so the final paragraph oftentimes have wherefore premises considered. Sometimes people will put these in commas, sometimes people won't. Let me see if I have any examples like that. This one does not end that way. Let's see if our model here, no, it doesn't end that way. That's a deposition notice. Oops. They're not showing us enough of the document here. And this does not have a wherefore premises considered. Here we have one, finally. You can see, and they've labeled this section the prayer section. It would have been nice if they had given this a Roman numeral 7. Wherefore premises considered. And what basically this is like saying in conclusion. You've heard our arguments, you've considered our arguments, therefore, and for whatever reason we say wherefore instead of therefore, this is what we want you to do. So this is kind of the conclusory section. What we're saying is, Your Honor, give us stuff. Do this for us. Take these actions. And that's how we will be satisfied. Let's see if this one has one too. Again, you don't have to use it. This one doesn't happen to have one. It's perfectly fine to use the language. Again, it's an example of boilerplate. A little bit old-fashioned, certainly not necessary. Let's look here at these examples. A prayer paragraph. And you can see it ends, wherefore, premises considered, Tracy Neff respectfully prays that Landmark's motion for summary judgment be denied. That is what Tracy Neff is requesting the court do. Now, you may be taken aback by the term praying. Well, I'm not praying, I'm filing something for court. And if I were praying, I wouldn't be praying to a human being, a judge. The term prayer, as we every day use that term, suggests a religious activity. But historically, it wasn't restricted to that. It involved a reference to speaking to somebody who is in a supplicant, speaking to somebody who's in a position of power when you are beseeching or requesting something. If you have read Shakespeare, you've probably heard, some of the characters say, I pray thee, or something along those lines. So again, it's not a disrespectful or sacrilegious thing. It just has a different meaning in this context. So that would be an example, and it's perfectly appropriate. If you don't want to use that terminology, you don't have to. Here we go. And I think we've already done this one, but let's look at, here we don't have that. We could imagine that the author, the writer, could have said, wherefore premises considered, plaintiff requests the court grant its fourth motion for continuance and reset the case for trial at a date after plaintiff has secured this needed discovery. But they didn't include it, so it's perfectly fine either way. And honestly, between you and me, it's probably better without it. But I wanted you to understand what it meant. A common thing that I do see in documents is that there will be unnecessary spacing. You do want to be consistent. And so sometimes what I will see is, well, there'll be only one space here and then there'll be 2 spaces above the next heading. I don't care so much whatever rule you follow about spacing between sections, you just need to be consistent. Now, the one time that you don't want to be consistent, or I guess it's consistent in a different way, is you don't, if you're doing a page break, it's perfectly fine then to have a blank section of the paper at the bottom because you wanted to have an appropriate page break. So that spacing, that's fine, that's understandable. But otherwise, just be sure that you're consistent. And again, the secret to doing that is just to turn on your Pilcrow and you'll be able to see all the formatting things that are going on in your document. So be sure to check that because that is a common situation that we get into. Okay, so now we're going to talk about a particular document that is important to know how to format. And this is an answer. So let's first of all talk about a little bit of terminology here. So the first document that's filed in a Texas state court we call a petition. This is filed by the plaintiff. And this name makes sense because the plaintiff is requesting something, right? I mean, you wouldn't be filing a lawsuit if you didn't want the court to do something. So you are petitioning or requesting that the court do something. So the name makes sense. But we have a different name when that same first document is filed in federal court. And we call that document a complaint. This name makes sense too. After all, if you're the plaintiff, you can even see in the word complaint, you have the beginning of the word plaintiff. So somebody who has a complaint is the plaintiff, right? I mean, you don't file a lawsuit if you're happy with everything. You're mad about something or you wouldn't be filing a lawsuit. So both of these names make sense, but they are the different terms, and it is important that you keep that straight. Texas state courts, we use the term petition. Texas federal courts, and in fact federal courts everywhere, we use the term complaint. Even though the names are different, for the most part the contents of the document are very, very similar. You're going to have the same content. I mean, there's a few details that are different. For example, in this document here, in a federal court, you wouldn't have something called discovery level. But other than this, I mean, it would be almost exactly the same format. This looks very similar to what you would have in a federal court. So the documents are very, very similar. So once the defendant is served with a lawsuit, then that defendant needs to file a document. And the defendant actually has several choices of documents that it can file, but the most common, the usual document is called an answer. And we call it an answer whether it's filed in Texas state court or in federal court. So that's nice, same terminology. And the name makes sense. After all, you are answering or responding to the allegations of the plaintiff. This is your opportunity to be heard to say, hey, no, that's not what happened. Let me tell you what happened. Or, okay, that is what happened, but I've got a good reason why it happened that way, or whatever the particular circumstances are. So the answer is going to have the same name whichever one the jurisdictions were in. But even though it has the same name, the document itself is very different in federal court versus state court. So in federal court, your answer is very detailed. You have to go through every single allegation in the in federal court in the complaint and decide whether it's true, so you would admit it, or whether it's false, so you would deny it, or whether you just don't know, so you would say, I lack sufficient knowledge to admit or to deny the allegations. You might say, well, why? I would just deny everything. Well, you can't do that. If you know something is true, you have to admit to it. And actually, even a very contentious litigation, there's always some facts that everybody agrees to. For example, plaintiff Larry Baxter, let's imagine this was filed in federal court. Plaintiffs Larry Baxter and Madeline Hebert, a minor. Well, do you know that Madeline Hebert is a minor? Well, she was employed by your place of employment, so you probably have a copy of some documentation that gives her age. And so you're probably going to admit that. And they are individuals residing in Dallas County. You may or may not know whether they reside in Dallas County or not, but you can see how, if you have that information, you would need to admit it. I mean, it doesn't really matter in terms of the underlying allegations, but it is probably a fact that you need to admit or to deny. Let's look at this paragraph. Is CEC Entertainment Inc., does it do business as Chuck E. Cheese's? Yeah, you'd have to admit to that. I mean, that seems to be probably true. Is it a corporation that is incorporated in Kansas? I'm guessing they got that fact right. And is its principal place of business in Irving, Dallas County, Texas? They probably got that right too. If they didn't get it right, then obviously you're going to deny it. But this is the type of stuff highly likely they got right. And do they have their registered agent? Is there a registered agent corporation service company on Brazos Street in Austin, Texas? I'm guessing that's right too. So all of these allegations you might end up admitting, or maybe in the case of this one, you might say we don't have enough information to admit. As you go through, there will be lots of other facts that you're going to admit to. You're probably going to admit to the fact that she started to work on a particular day. But then there will be facts that you're probably not going to admit to. So those are, you have to go through each paragraph. Let's look at paragraph 8 just to see how this would go. Almost from day one, Miss Abear's supervisor, Harold Smith. So I'd say, well, you're probably going to admit that Harold Smith was Miss Abear's supervisor, okay? But let's look at the next phrase. Began making unprovoked and unwelcome sexual advances towards her. Well, I'm hoping you can you can deny that. If you can't deny that, then you're not going to have much of a case, right? So this is something you're going to deny. And then you have to go to the next sentence. Mr. Smith's advances started with comments and compliments about Miss Abear's appearance. Again, you're probably going to deny this, but let's say Mr. Smith says, well, you know what? I did compliment Miss Abear's appearance one day. She was wearing her hair in a new way, and I said, that's very attractive. So you might feel like that you need to admit that Mr. Smith gave Miss Abear a compliment once, but you're denying the rest of the allegations. Looking at the next sentence, Mr. Smith, an adult member of the restaurant management team, so that looks like it's true. Probably Mr. Smith is an adult, and he's probably a member of the management team. Told the 15-year-old that she was pretty. That could have happened. Let's assume it did. You're going to have to admit to it. He made comments to Miss Abear and other employees about how good she looked. So that's a possible, maybe that's true. Maybe you're going to have to admit that. Maybe it's not true. But you can see going through is a very lengthy process. As a result, in federal court, it's not unusual for the answer to be longer than the original petition. Another thing about federal answers is a lot of times they don't really make sense unless you have the complaint next to it, because you're just kind of admitting and denying little scraps of information. So that's how you do it in federal court. But we're not doing things in federal court in this course, so thank goodness we don't have to worry about that. So we're going to talk about how we do the answer in Texas state court. It's a lot easier. Yay! Okay. So what we do in Texas state court is we usually file something called a general denial. I'm just going to pull up the rule here. I'm just going to copy this and open up the rule. I don't think I have it still up here. No, I don't have it. Okay. And this is the rule about general denials. A general denial of matters pleaded by the adverse party which are not required to be denied under oath shall be sufficient to put the same in issue. When the defendant has pleaded a general denial and the plaintiff shall forward amend his pleading, such general denial shall be presumed to extend to all matters subsequently set up by the plaintiff. So basically, what you can do, it's a little bit like in a criminal case. Let's say I've been charged with murder. I get to plead not guilty. By pleading not guilty, I'm not saying to anybody, hey, I am factually innocent. I mean, I may be factually innocent, but what I'm saying is I want to require that the prosecutor prove his or her case. And even if there's very strong evidence that I'm guilty, he's going to have to present that evidence to the jury. I'm not guilty of perjury, though, if it ends up that, yep, I did it. Maybe even I admit to doing it during the course of the trial because I wasn't saying factually that I'm innocent. I'm saying, Your Honor, I want the prosecutor to be required to prove his case. So the general denial is the same type of thing. You're saying, hey, I want the plaintiff to bear his burden of proof. And so I'm not going to say there's probably some stuff in here I would agree with, but there's some stuff I wouldn't. I'm saying they've got to prove their case. Okay. So here, so general denial is, again, that one sentence response. It can be more than one sentence, but it's pretty common that it just be a single one or two sentences that basically says, prove your case, prove it. So as a result, when you're filing your answer as a defendant, you don't even have to know what is true and what's false about the plaintiff's case. You can just go ahead and file a general denial, even if it ends up that every single statement in the plaintiff's petition is actually true. This is an example of how you might write a general denial. The defendant asserts a general denial as authorized by Rule 92 of the Texas Rules of Civil Procedure and respectfully requests that the plaintiff be required to prove the charges and allegations against the defendant by a preponderance of the evidence. So this accomplishes the task. So all those numbered paragraphs that you'd have in a federal answer get replaced by just this one or two sentence statement. This is a really long sentence, but it's okay because this is, again, a kind of a boilerplate thing. Now, this doesn't mean that every single answer in Texas fits on one page, although many do. You can also have additional things that you want to add in addition to the general denial. For example, you might have some affirmative defenses to assert. I'm not going to really talk about those because that's something you'll learn about in civil litigation. But these would be things like maybe the statute of limitations has ended before the lawsuit was filed. So you'd want to plead that, because if you don't specifically plead it, you can't advance that argument later on. Or maybe you want to make a counterclaim. Well, again, you would need to plead that. But if all you want to do is just tell the court, Your Honor, I want to insist that the plaintiff prove his case, all you need to have is a general denial. That accomplishes the task that is at hand. So this is a particular document I wanted to spend a little bit more time on because it's an important one to know the particular aspects of Texas formatting and to know the distinction between federal court and state court. At this point, we're going to end this presentation. In our next presentation, we're going to talk about the signature block and some other aspects of the document. But you might want to, before you went ahead with the signature block, is go ahead and carefully proofread your document. When you choose to do that is kind of your own call. You might want to wait until you've got everything set up, or you might want to just do the body when you are to that stage. So again, you're going to want to use all the tools we talked about before. If you're going to proofread, you're going to go over here to File. You're going to go to Options down here at the bottom, and you're going to go to Proofing. You're going to make whatever choices you have here. You're going to hit OK. And then you can go through your document, going Review and hitting Spelling and Grammar to see all of the typos and other errors. Word is super helpful with respect to this, but you can't blindly accept what Word says. Word is going to not like some of the formatting things that we're doing. Plus, you are going to want to correct some things that Word didn't see itself. So use Word, but don't use it blindly, and don't forego a careful read and reread of your document independent of Word. I hope that this information has been helpful, and I hope that you have a wonderful day. Thanks for your attention.